should be at least 60% Filipino-owned, it's implementing rules and regulations, Mr. Chair, inadvertently required that generation of renewable energy must be at least 60% owned by Filipino nationals. The impact of such inadvertence, Mr. Chair, as shown in the energy mix of the Philippines in 2022, nearly 15 years after the enactment of the RE law, the RE capacity, the RE capacity of the Philippines, the total generation was at 22%, Mr. Chair. The installed capacity was at 8.624 megawatts, Mr. Chair. And then in 2022, the amended Public Service Act retained the treatment of distribution of electricity and transmission of electricity as public utilities. The generation and supply of electricity remained open to full foreign ownership. So following the pronouncements of an energy secure Philippines of the President Marcos Jr. during his first SONA in July 2022, Secretary Lutilla and the Department of Energy undertook public and legal consultations and solicited DOJ's opinion on the 60-40 limitation under the RE law IRR. The Department of Justice opined that the exploration, development, and utilization of solar, wind, hydro, ocean, or tidal resource should not be subject to 40% foreign equity limitation on the basis that these resources are inexhaustible. Consistent thereto, Mr. Chair, the Department of Energy issued Department Circular 2022-1134, which lifted the previous limitation on foreign ownership in connection with the exploration, development, utilization of solar, wind, hydro, ocean, tidal resources on November 2022. A few weeks after the amendment of the Renewable Energy IRR, CIP, or Copenhagen Infrastructure Partners, became the first foreign investor to be granted site exclusivity in the Philippines to develop an RE project. On March 2023, a few months after the issuance of the new IRR, it became the first 100 foreign-owned company to be awarded renewable energy service contracts in the country. CIP, or Copenhagen Infrastructure Partners, is investing $5 billion to develop 3 offshore wind energy projects in the Philippines with potential capacity of 2,000 megawatts or 2 gigawatts, Mr. Chair. 1,000 megawatts in Camarines Norte and Sur, 650 megawatts in Northern Samar, and 350 megawatts in Pangasinan and La Union. It will create 4,500 jobs, generate enough power to supply 1 million households, and offset about 2.9 million tons in CO2 emissions per year. In 2023, Mr. Chair, the Board of Investments approved approximately 52 power projects for registration. The projects are located across the country with a total capacity of 4.7 gigawatts, an aggregate project cost of 987 billion pesos and 123 million pesos, Mr. Chair. 80% of the almost 1.3 trillion FDI registered under the BOI in the year 2023 alone are energy projects. To name a few, Mr. Chair, the Triconti Sea Wind Partnership is currently developing 1.65 gigawatts of offshore wind capacity in Luzon and the Visayas, from which 3,600 direct and indirect jobs could be generated. These are all located also in the Guimaras Strait Wind Power Project, Guimaras Strait 2 Wind Power Project for offshore wind service contract, as an initial investment cost of 221 billion pesos with total target capacity of 1.2 gigawatts. The Burgos Pangasinan Solar Energy with 2.7 billion solar project is expected to generate 500 jobs, Mr. Chair. Blue Float, one of the most ambitious wind project developers by a foreign investor in the Philippines, Blue Float Energy, announced its entry in the Philippines on June 2023 with 4 wind energy service contracts in Central, North, South Luzon, and another in Southern Mindoro. This is the biggest project, Mr. Chair, with 4 sites and a total of 7,500 megawatts, Mr. Chair. Although Blue Float is the biggest, it is one of the few, of the many foreign direct investors in renewable energy. After opening renewable energy to 100% foreign investment, DOE has received a surge in the number of applications, significantly increasing the number of potential megawatts in renewable energy. Foreign investors such as Ignis of Spain, Macquarie of Australia, Nexif Ract from ASEAN, Copenhagen Energy from Denmark, and numerous investors from Europe, Australia, and Asia, including China, hold service contracts for renewable energy, most especially in offshore wind, onshore wind, ground-mounted solar, and floating solar. Today, we have processed an additional from 2022, since the approval of the new IRR, up to December 2023, we have 400 applications for RE service contracts. We have awarded for 2023 alone 275 service contracts with a potential capacity of 39,622 megawatts for a total of estimated cost of investment of 8 trillion pesos, 8.52777 trillion pesos. For power generation alone, for 2023 alone, 275 RE new contracts at 39.6 gigawatts of potential capacity. The investments cost are 100 million per megawatt for offshore wind, 50 million pesos per megawatt for solar, and 70 million per megawatt for onshore wind. For employment, Mr. Chair, in 2022, an estimated 459 workers were in RE. Based on this data, it is estimated that job generation is 10 direct jobs and 30 indirect jobs per megawatt is expected. Estimated direct and indirect job generation for 2023 new contracts based on the potential capacity is at least 1.5 million positions, Mr. Chair. Other than the investments in the development of renewable energy, the other components that will come in because of all the investments, of the trillions of investments from foreign investors, is the port development, which we will need at least 10 new ports in order to cater to the offshore wind projects. On mining, the batteries components include rare earth metals from our indigenous resources, including vanadium and scandium from our indigenous black sand. The additional transmission lines, including a newly proposed smart and green grid, will also require more copper. Manufacturing, a number of foreign companies have already visited the Philippines and are looking for sites to manufacture turbines, controllers for semiconductors, all components for manufacturing like blades, turbines, towers to be locally produced, Mr. Chair. On December 2023, as a result of all this, on December 2023, among 110 countries, only behind India, mainland China, and Chile, Philippines was declared by Bloomberg NEF as the fourth most attractive developing countries for clean energy investment, Mr. Chair. I would like to emphasize, though, that opening the industry to foreign investment is not the only thing that propelled the industry. We had policies like the EO21 policy for administrative framework for offshore wind, EO18 for the green lane for strategic investments in BOI, EVOS for the automation and streamlining of applications, programs like the Renewable Portfolio Standards, which we increased to 2.52%, renewable energy market, the auctions, we are already on the green energy auction for the third time, green energy option program, preferential dispatch, feed-in tariff, renewable energy trust fund, and of course, we have the incentives under the RE law and the CREATE law. There is a huge social and economic impact when you liberalize an industry, as shown in the renewable energy. There's the technology transfer, the human capacity building, funding and financing. We have more access because because our foreign investors have more access to foreign funding and financing. The energy transition is also an important component or result of such liberalization. Mr. Chair, the President, during his State of the Nation address in 2023 said, renewable energy is the way forward. We are aggressively promoting renewables so that it provides 35% share in the power mix by 2030 and then 50% by 2040. With the liberalization of renewable energy generation and supply, this mandate of the President will be made possible. Mr. Chair, if there is a question of the effect of liberalizing an industry, especially a utility, to foreign investments, then the renewable energy industry is proof of concept. If you open it, they will come. Thank you, Mr. Chair.
Thank you very much, Yusek Karin. Floor Leader.
Mr. Speaker, may we request Mr. Ernesto Silvano Jr. from NEA if he has any presentation? Mr. Ernesto Silvano, Mr. Chair.
Good afternoon, Mr. Chair.
The Chair would like to recognize Mr. Ernesto Silvano Jr., Deputy Administrator of Technical Services, National Electrification Administration. You have the floor. Please proceed.
Good afternoon, Mr. Chair. I am Ernesto Silvano from NEA. In behalf of the Administrator.
Do you have any statement?
No, on our part, we would like to request to have more time in preparing for the formal position paper, as we just received the invitation a day ago. Thank you.
Thank you, Floor Leader.
Yes. Mr. Chair, next in line is the chairperson of MWSS. May I request Attorney Elpidio Vega to make a statement or make his presentation if he has any.
Thank you, ma'am. Good
Please
afternoon.
proceed.
Under Republic Act 6234, the MWSS Charter, the Metropolitan Waterworks and Sewerage System has jurisdiction, supervision, and control over all waterworks and sewerage system within the Metro Manila, the entire province of Rizal, and a portion of province of Cavite. Subsequently, RA 8041, or the National Water Crisis Act of 1995, as implemented by EO 296, dated December 6, 1996, and EO 311, dated March 20, 1996, mandates the MWSS to enter into arrangements that will result in the involvement or participation of the private sector in any of all the segments of its operation under and/or facilities. Thus, the concession agreements dated February 21, 1997, MWSS and the concessionaires, Manila Water Services for the West Service Area and the Manila Water Company for the East Service Area, mutually agreed, in which the concessionaires are granted the right to operate the waterworks and sewerage services in the service area for the period specified therein. The revised concession agreement, which the MWSS signed with Manila Water Company, was finalized on March 31, 2021, and with Manila Water Services on the 18th May 2021. Under RA 11659, or Act amending CA 146, otherwise known as the Public Service Act, categorically demarcated the status of MWSS as public utility and specifically included the water pipeline distribution and wastewater pipeline system, including sewerage pipeline system, as regulated by RA 6234. Thus, the public utility refers to the public service that operates, manages, and controls for public use any of the following: the water pipeline distribution system, and wastewater pipeline systems, including sewerage pipeline system. As such, MWSS and its concessionaires fall squarely within the realm sought to be affected by the proposed amendments. MWSS finds the underlying goal of the subject bill to liberalize industries, promote efficient service delivery, and foster competition as a policy to be commendable, and respectfully submit the particular amendments affecting public service as crucial to MWSS. Thus, as the above pertains more of the ownership structure, MWSS is explicitly recognized as a government instrument with corporate powers, or GCEs, under RA 10149. An instrument or agency of the government which is neither a corporation or agency integrated within the department framework vested by law and special functions and jurisdiction. Furthermore, MWSS is organized neither as a stock or non-stock corporation, rather its full ownership belongs to the national government. As such, the above proposed amendments would have direct effect on its ownership structure unless its very nature is in accordance with its charter is amended. However, under the existing concession system, MWSS has three concessionaires, namely Manila Water, Maynilad, and more recently, Luzon Clearwater Development Corporation, all classified as public utilities under Revised Public Service Act. While the ownership structures for these concessionaires have foreign participation, these are presently maintained below the threshold currently set by the 1987 Constitution. Moreover, Section 19 of the respective franchise laws of the MWSS concessionaires identically state that in accordance with the constitutional provision to encourage public participation in public utilities, the grantee shall offer to Filipino citizens at least 30% of its outstanding capital stock and such other percentage that may hereafter be required by law in any securities exchange in the Philippines within 5 years from the effectivity of this act. Non-compliance therewith shall render the franchise ipso facto revoked. Thus, we ultimately submit to the wisdom of the House, and we would like to underscore the flexibility resulting from the inclusion of the phrase unless otherwise provided by law, which could result in future scenarios wherein the ownership structures of the MWSS concessionaires or any critical public utility could be fully foreign, or if provided and allowed by the subsequent laws, alternatively have a Filipino ownership percentage. However, this would be dependent upon the necessity suitable and favorable to the economy. Thank you, Mr. Chair.
Okay. Thank you very much, Attorney Elpidio de Vega, Chairperson of MWSS. Floor Leader.
Mr. Chair, I move that you recognize Attorney Sharon L. de Chavez Aledo of Marina.
The Chair would like to recognize Attorney Sharon de Chavez Aledo of Marina.
Thank you, Mr. Chair.
Proceed with your opening statement.
Good afternoon, Mr. Chair and members of the Committee of the Whole House. I am Attorney Aledo of the Maritime Industry Authority. We laud the noble intention of Congress in taking the initiative in proposing amendments to our Constitution to effect timely and necessary changes therein. The crucial role of the domestic shipping industry in the Philippine economy cannot be overemphasized. It serves as a conduit in local trade and commerce while enabling more affordable means of inter-island transportation. the passage of RA number 11659, or an act amending Commonwealth Act number 146, otherwise known as the Public Service Act as amended, is a response of the state to the clarion call for the rationalization of foreign equity restrictions enshrined in our Constitution to foster competition in the domestic shipping industry and stimulate national growth and development. Concomitantly, in order to complement the policy of the state in encouraging foreign ownership participation in domestic shipping, the Marina acquiesced in the liberal interpretation of the provisions of the law of the new Public Service Act and promulgated the implementing rules and regulations that will give effect to the same, and this is Marina Circular Number DS 2023-02, entitled Guidelines on Domestic Shipping as Public Service, pursuant to RA 11659 and its implementing rules and regulations. Thus, domestic shipping is now categorized as public service, and no foreign equity restriction is imposed on the same. Nonetheless, the inclusion of domestic shipping as a public service in the Public Service Act as amended will bear both a positive and negative impact in the maritime industry. Filipino stakeholders will be at a disadvantage since they will have to compete with more financially equipped foreign investors. Further, the presence of foreign ship owners and or operators in the country may mean that our safety and security will also be at risk. The risks in terms of national security through violence, hijacking, piracy, terrorism, and other dangerous acts may also be a considerable threat to the country's maritime industry. On the other hand, with increased capital investment, the country's maritime industry will increase its revenues, which will be beneficial in the achievement of more long-term projects and improvement of infrastructures. Further, the entry of foreign investors in the maritime industry will improve our merchant fleet, since they will promote competition and bring along modern technology and influence from other foreign countries. It is noteworthy, further, that the proposed amendment in the Constitution will allow, by law, 100% foreign equity in all educational institutions. In accordance with this mandate as a single maritime administration under RA 10635, the Marina would very much welcome any beneficial competitiveness and progress in all maritime educational and training institutions. The Marina interposes no objection on the subject amendment since there are safeguards in place to ensure the regulation of educational institutions that may solely be owned by foreigners, which refer to the requirements of control and administration by Filipino citizens. The Marina does not object to the proposed amendments provided that the regulation of maritime higher educational institutions, or MHEIs, is strictly subject to the relevant rules and regulations of the Marina and the Commission on Higher Education, and that their compliance with the International Convention on the Standards of Training, Certification, and Watchkeeping for Seafarers, or the STCW Convention, and other relevant international laws, conventions, is not jeopardized with the amendments. Notwithstanding the aforementioned, the Marina respects the wisdom of Congress on any initiative to amend the Constitution. The Marina remains committed in complying with our mandate as the flag administration of the Philippines. Thank you, Mr. Chair.
Okay. Thank you, Attorney.
Mr. Chairman.
Yes.
Yes. Can I just make a request?
Yes, Suarez.
Thank you very much. Can I just make a request that copies of the presentations by our resource persons be furnished to the committee so that members can be given a copy, just so that we can review once we deliberate on the matter? Thank you, Mr. Chair.
Okay. We will, the chair directs the secretariat to get hold of the copies from our resource persons.
Mr.
The
Chair.
position papers. Okay.
Mr. Chair, in addition to that, may we request the Secretariat, in addition to the motion of the Honorable Co-Chair, Mr. Chair, may I also move that if soft copies are already available, be it uploaded in the all members chat group so that they can peruse over it while the Secretariat is reproducing.
Okay, the chair directs the secretariat to do so.
Thank you, Mr. Chair. I now move that we recognize Attorney Ella Blanca Lopez, Commissioner of the National Telecommunications Commission.
The chair would like to recognize Attorney Ella Blanca Lopez, Commissioner, National Telecommunications Commission. Please proceed.
Honorable Chairperson and members of this honorable committee, colleagues in public service, ladies and gentlemen, good afternoon. The National Telecommunications Commission extends its appreciation for allowing us to share our views and comments on the measured resolution of both Houses Number 7, specifically on Section 11, Article 12 of the 1987 Constitution regarding the franchise and nationality requirement for public utilities. The NTC regulates, among others, the telecommunications service industry in the country. Previously, telecommunication industry is subject to the 60-40 nationality requirement. But with the enactment of RA 11659, or the Act amending the Public Service Act in 2022, telecommunications service or entity was removed from the term public utility, but still a public service. In that regard, telecommunication service entities is therefore no longer subject to the nationality requirement for public utilities under Section 11, Article 12 of the Constitution. The NTC fully supported the passage into law of RA 11659, and we shall continue to support the purposes of the herein initiatives of Congress and the present administration, which we firmly trust will make our legal and regulatory framework more adaptive and responsive to the ever-changing needs of time. Thank you very much, Mr. Chair.
Thank you very much, Commissioner Lopez. Floor leader.
Mr. Chair, I move that we recognize Attorney Mark John Palomar of the Philippine Ports Authority.
The chair would like to recognize Attorney John Mark Palomar of the Philippine Ports Authority. Please proceed with your opening statement.
Thank you. Good afternoon, Mr. Chair. Good afternoon to the members of the Committee of the Whole House. This refers to the resolution of both houses, number 7, or a resolution of both houses of Congress proposing amendments to certain economic provisions of the 1987 Constitution and the Republic of the Philippines, particularly Articles 12, 14, and 16. We take this opportunity to present our comments on the proposed amendments as follows. On Article 12, National Economy and Patrimony, Section 11 of Article 12 is amended. Incorporation of the phrase otherwise provided by law would render nugatory the supremacy of the constitutional provision of Philippine citizenship and capital as a prerequisite for the granting of franchises, certificates, and other forms of authorization for the operation of public utilities. The Constitution is the supreme law of the land. It cannot be simply modified or altered by statute enacted by Congress. The proposed amendment on the first paragraph of Section 11 of the Article 12 would negate the basic principle enshrined in the 1987 Constitution providing for the operation of public utilities to be exclusively enjoyed by Filipinos or Philippine corporations who meet the 60% nationality requirement. Likewise, the proposed amendment modifying the last paragraph of Section 11 of Article 12 would be to the effect that Congress is allowed to enact legislation increasing the participation of foreign investors in the governing body of any public utility, which would be inconsistent with the state's principles to assure the management and control of public utilities by Filipino citizens. By adding unless otherwise provided by law in both paragraphs, the proposed amendments would give Congress a wide latitude of discretion to disregard or contravene the letter and intent of the Constitution to develop a self-reliant and independent national economy effectively controlled by Filipinos. The nationalization of public utilities and consequently the limitation of foreign participation are also evident in other provisions of the Constitution. Efforts to harmonize related provisions must be maintained. The proposed amendments would create a disparity as it would be in conflict with Section 10 of Article 12 of the 1987 Constitution, which provides in the grant of rights, privileges, and concession covering national economy and patrimony, the state shall give preference to qualified Filipinos. In addition, the proposed amendment would likewise result in impossible inconsistency with the following state policies. Number 1, the state shall develop a self-reliant independent national economy effectively controlled by Filipinas, which is Section 19, Article 2 of 1987 Philippine Constitution. Number 2, the state shall provide industrialization and full employment based on sound agricultural development and agrarian reform.
Mr. Chairman, we'd just like to ask the resource person to speak in front of the mic so that we can hear you and slowly.
My apologies.
Because we are really very intent on listening to you. Thank you. Can you do that?
Okay.
Thank you.
Our resource person. Yes.
Yes.
Please proceed.
The state shall promote industrialization and full employment based on sound agricultural development and agrarian reform through industries that make full and efficient use of human and natural resources and which are competitive in both domestic and foreign markets. However, the state shall protect Filipino enterprises against unfair foreign competition and trade practices. Section 1, Paragraph 2, Article 12, 1987 Philippine Constitution. Number 3, the state shall protect the nation's marine wealth in its archipelagic waters, territorial sea, and exclusive economic zone, and reserve its use and enjoyment exclusively to Filipino citizens. Section 2, Paragraph 2, Section 12, 1987 Philippine Constitution. Thank you for giving PPA the opportunity to give comments on the said bill. A copy of this position paper has been submitted to the Secretariat. Thank you.
Thank you, Attorney Palomar. Floor Leader.
Mr. Chair, I now move that we recognize Attorney Jose Ronald Valles, Senior Vice President and Head Regulatory Management Office of the Manila Electric Company, Meralco.
Good afternoon, Mr. Chair. Good afternoon,
Attorney
members
Valles,
of Congress.
please proceed with your opening statement.
Sorry, apologies. Good afternoon, Mr. Chair and members of the House. Meralco notes that as a public utility, it is fully compliant and is satisfied with the 60/40 ownership requirement under the 1997 Constitution and the recently amended Public Service Act. However, we extend our full support to the objective of both resolutions, particularly on seeking to enable higher foreign ownership of public utilities in the Philippines. We believe that this measure holds significant potential to attract substantial investments into the Philippines power sector, fostering infrastructure development, modernization, and expansion, spark greater competition within the industry, potentially leading to improved service quality and lower prices for Filipino consumers, address potential supply shortages, and enhance the nation's preparedness for future energy demands by diversifying investment sources and stimulating innovation in the sector. And finally, contribute to the broader economic growth and development by fostering a more dynamic and competitive power sector. We believe that alongside this potential for growth, it would be crucial to strengthen the capacity and resources of regulatory bodies overseeing public utilities, subject to certain limitations to protect national security interests as may be determined by Congress. This would equip them to effectively monitor and enforce regulations, ensuring fair competition and consumer protection. We are grateful for the opportunity to discuss our comments or views on the RBH number 7. Thank you, Mr. Chair.
Thank you, Attorney Valles. Floor Leader.
Mr. Chairman, I now move that we recognize Mr. Ruel Z. Castro, President and Chief Executive Officer of More Electric and Power Corporation.
The Chair would like to recognize Mr. Roel Castro, More Electric Power Corporation. Please proceed with your opening statement.
Mr. Chair, good afternoon. We just received the communication yesterday, and we haven't had the opportunity to consult with private distribution utilities sector, Mr. Chair. However, for the position of more power, electric distribution, as it is in the Constitution now, is 60/40 as a public utility. As we very well know, it is working as it is now. However, we also recognize the fact that efficiencies are needed at the last mile, which is at the distribution utility. As it is proposed on the amendment, we are supportive of it because there is actually a safeguard that the franchise would have exemption as would deem necessary by the Congress, Mr. Chair. So that's our position on this, Mr. Chair. Thank you.
Floor Leader.
Mr. Chair, I now move that we recognize Mr. Michael Ted Macapagal, Chairman of the Philippine National Railways. It's still part of the regulators, and we just skipped him because he just arrived. So Mr. Michael Ted Macapagal of the Philippine National Railways, Mr. Chair.
The chair would like to recognize Mr. Michael Ted Makapagal of the Philippine National Railways. Please proceed.
Good afternoon, and thank you, Mr. Chair, to the honorable members of this committee. Good afternoon. The Philippine National Railways was requested to comment on the proposed amendments to certain economic provisions of the 1987 Philippine Constitution. Given its nature as a public utility, the PNR most respectfully submits its position paper limiting its comments on the proposed amendments to Section 11 of Article 12, National Patrimony and Economy. The PNR would like to commend both houses of Congress for their efforts in pursuing legislative reforms that address the changing needs and demands of the country's economy. The PNR supports the proposed amendment, considering that the phrase, unless otherwise provided by law, categorically requires the Congress to pass laws that would specifically govern a particular kind of public utility. Through these future legislative enactments, matters concerning a specific public utility can undergo meaningful discussions and deliberation. In turn, this would eventually result into the adaptation of rules and regulations or policies that are responsive to the dynamics of particular public utility and in a larger scale to the changing needs of the economy. However, the PNR would like to discuss its observations regarding the implications that may go along with the proposed amendment. On the procedure to amend a constitutional provision, the 1987 Philippine Constitution provides that an amendment to the Constitution may be proposed through Constitutional Assembly, Constitutional Convention, or People's Initiative. Along with its support to this proposed amendment, the PNR would also like to ensure that the proposed amendment will undergo the constitutionally mandated process for amending its provisions, which shall be undertaken subsequent to the Senate resolution. On the possible consequences of the proposed amendments to PNR, it is also imperative to discuss the possible consequences of the proposed amendments to PNR. To reiterate, the PNR is a government instrumentality and at the same time an agency attached to the Department of Transportation. Currently, the DOTR has already awarded several contracts to foreign corporations for its ongoing railway projects. In particular, the DOTR has awarded numerous contracts for civil works in relation to the North-South Commuter Railway project. Moreover, the bidding for the operations and maintenance contract of the NSCR project commenced in the fourth quarter of 2023 until the first quarter of 2024. This is consistent with the definition of concession under Section 2C of the Public Service Act as amended. The technical expertise and financial capabilities of foreign corporations in constructing, maintaining, and operating railway transport systems provide economic advantages to the country. The advanced technological knowledge that foreign corporations possess will significantly contribute to the development of modernized railway transportation system in the Philippines. Undoubtedly, this public-private partnership initiative of the government by entering into concession agreements with foreign corporations guarantees to provide technological advancements in the management, operations, and maintenance of PNR railway services. Nonetheless, PNR also believes in ensuring that safeguard provisions are incorporated in laws that will be passed and subsequently implemented involving public utilities. While acknowledging the advantages that foreign investors will bring and contribute to railway transportation in the Philippines, the PNR continues to support and adhere to the Filipino First policy as intended by the present Constitution and relevant laws. In this regard, the PNR opines that safeguard provisions should be expressly provided in the subsequent legislation that the Congress will pass involving public utilities. This is to ensure that business and employment generate opportunities for Filipinos, prioritizing the benefit of our own citizen above others. In conclusion, the PNR commends and supports both houses of Congress for their intention in promoting, among others, efficient transportation services in the Philippines through this proposed amendment. This is consistent with the PNR's objectives to provide safe, reliable, and efficient railway transport in the Philippines. Adhering to the Filipino First policy guarantees business and employment opportunities for Filipinos that will accompany foreign investments. The PNR will continue to support the government's programs for reform that will provide better services for the Filipino, particularly to the Filipino commuters and to the local labor force that would benefit through future legislations involving public utilities. Thank you all very much, and again, good afternoon.
Floor Leader.
Mr. Chairman, I move that we recognize Attorney Stephen Rodriguez of the North Luzon Expressway. NLEX.
Of
NLEX, Mr. Chair.
Attorney Stephen
Attorney Stephen Rodriguez.
Rodriguez. Penlex. Please proceed.
Thank you, Mr. Chair. Good afternoon, Mr. Chair and the honorable members of this committee. We would like to inform this honorable body that we just received the invitation for this committee hearing last night, and our company would like to request or be given for additional time to further study this matter and to submit its comment or position on this matter. Thank you, Mr. Chair.
Mr. Chair.
Floor Leader.
I now move that we recognize our former colleague, Attorney Nery Colmenares, a lawyer and former member of this House of Bayan Muna Party List.
The Chair would like to recognize our former colleague, Attorney Nery Colmenares. Please proceed.
Thank you, Mr. Chair. I just have a few slides, Mr. Chair, on public utilities. I'd like to request the Secretariat, if I may, to present the slides in our screens, Mr. Chair.
Secretary,
Yes.
okay.
Thank you, Mr.
Okay, we
Chair.
already have it there. Please proceed.
The first slide, please. We are tackling today the intention to, the first slide, yes. Opening up the public utilities to aliens. In my opinion, Mr. Chair, it will have implications. One, public utilities. Ano ba ang public utilities? Napaka-importanteng industriya po ito sa isang bansa. Tubig, kuryente, transportasyon, komunikasyon, na dapat hawak nga po yan sana ng gobyerno. Hindi yan pwede sa pribado. Kasi the moment it's privatized, of course, service is just an afterthought and profit is the main motivation. Ang problema dito, pribado na, dayuhan pa. So public service to the Filipino people becomes service to foreign stockholders. That's our first, that's the first implication, Mr. Chair. The second is, of course, national security implication. Hindi ba tayo natatakot pag hawak ng isang dayuhang bansa, ang ating kuryente, ang ating tubig, pati nga transportasyon at komunikasyon, may problema tayong malaki. Because this is the lifeblood of society, Mr. Chair. So, kung mabuksan natin, pwede na po ba mag-increase ang China from 40% to 80 or 90% sa NGCP? Pwede na bang pumasok dito yung ibang bansa? Pag hawak ng China, for example, Mr. Chair, ang malalaking generation or distribution utilities natin, may konting gulo sa West Philippine Sea, iba-blackout niya lang yung Luzon, luluhod tayo sa China. Is that something we anticipate, Mr. Chair? In fact, ang problema dito, Mr. Chair, natatakot ako, nuclear power plant. What if an alien or transnational corporation puts up a nuclear power plant as a, as a generation utility? Because there's no prohibition as far as the Constitution is concerned, he or she will argue. That's the first. The second, Mr. Chair, is of course, ang tingin ko, ang term ko kahapon, a ship with aimless economic direction in an ocean of contradictory policies. Contradictory, Mr. Chair. Kasi tingnan natin yung ina-amend natin dito. No franchise certificate or any other form of authorization for the operation of a public utility shall be granted except to citizens of the Philippines or to corporations or associations organized under the laws of the Philippines, at least 60% of whose capital is owned by such citizens unless otherwise provided by law. So ibig sabihin, pwede palang ang batas, tataasan niya ang foreign equity or capital or share doon sa public utility. But look at the next sentence, Mr. Chair. The state shall encourage equity participation in public utilities by the general public. If we say general public, Mr. Chair, Pilipino yan. So, how can you encourage equity participation sa mga Pilipino, binuksan mo sa dayuhan ang public utility mo? Next slide, please. So, itong naman, Mr. Chair, tingin ko discriminatory po ito. Basahin po natin ang nakalagay sa bill. Unless otherwise provided by law, the participation of foreign investors in governing bodies of any public utility enterprise shall be limited to their proportionate share in its capital. Is there anything wrong with that, Mr. Chair? Simple lang po ang pagkaintindi ko dyan. I may be wrong. But isn't it correct na ang isang investor, ang kanyang share sa management or governing body ng any corporation is limited to their share of in capital? Ibig sabihin, pag 40% ang share mo, hindi 40% ka sa governing board. Bakit naman hahayaan mo ang foreigner na magkaroon ng more power in seats in the governing board above his or her share in the capital? Nagtaka ako bakit siya unless otherwise by law, wala naman ako nakita pong problema dyan. Of course, I'm willing to listen to the explanation, pero right there and then, discriminatory ito sa mga Pilipino kasi tayo, ang mga Pilipino, kung 40% ka lang sa korporasyon, ang expected 40% ka rin ng board of directors. Pero ang foreigner pala, pag unless otherwise provided by law, 40%, 60% lang siya doon sa board, pero 80-90% ng seats kanya. Yun po ang kuha ko dyan sa discriminatory policies. So, next slide please. Yung sa educational, just nandito lang naman tayo, kasi may kapareho rin po niyan na problema. Kung titingnan nyo po, para sa akin, ang edukasyon, yan po, ang under po yan sa konstitusyon natin, siya ang pinagmumulan ng patriotism and nationalism and service to the Filipino people ng ating susunod na henerasyon ng mga kabataan. Nakalagay po yan sa konstitusyon.
Mr. Chairman, point of order, Mr. Chairman. Today
Representative Rodriguez, please take
regarding
the point
my
of
good
order.
friend, Congressman Colmenares. Today is about public utilities. And so therefore, let us limit on public utilities, and we'll ask our good colleague to be present on Monday, so
Yes.
that we can take up education, so that we will not mix the issues. The issue for today is the amendment on public utilities, unless otherwise provided by law. Thank you, Mr. Chairman.
Okay,
Thank
the Chair would like to recommend our resource person will stick to
Yes.
the amendment scheduled for today, which is public utilities.
Thank you, Mr. Chair. I just mentioned that because there's another similar provision on education with regards to conflicting policies wherein Filipinos are encouraged to have equity participation in education, but at the same time, you're going to put in foreigners. But thank you for the clarification from our colleague, Honorable Rodriguez. Thank you, Mr. Chair. So basically, ang ending ko dito is this. Ano ba talaga ang ating gagawin sa public utility? Ang sabi, to encourage investors, bubuksan natin sa foreign, so transnational corporations or sa aliens. Marami namang pumapasok na investors say sa China or sa Vietnam, hindi naman nila pinapayagan ang aliens na maghawak ng kanilang public utilities. So parang hindi ko nakita yung 1+1. sila, hindi naman nila hinahayaan na ang public utilities hawak ng mga aliens, pero may investors. Tayo, bakit natin din na-justify ang pagpasok ng investors by allowing them to control the lifeblood of our country, which is the industries that are most important to the Filipino people. Yan po siguro yung problema dyan pag binuksan natin. Tapos, pag dinefine mo yan, ang public utility like kuryente or tubig, ano po yan may linkages po yan mula sa generation, mula sa hydro, mula sa dam. All these things papasok, Mr. Chair, na tingin ko delikado pag pati mga resources natin ay hayaan under the guise of opening up public utilities to aliens. So in the end, Mr. Chair, para sa akin, ang foreign investment is of course an important component of any economic development. Pero sa akin po, that is the secondary engine of growth. Para sa akin, dapat ang focus ng Kongreso, ang focus ng gobyerno is not opening or liberalizing our economy, but rather on the primary engine of growth, which is national industrialization. National industrialization, Mr. Chair, simple lang sigurong definition ko dyan, it is buhos kapital at suporta ang gobyerno sa lokal na negosyo at industriya. Pag magsusulputan po, Mr. Chair, ang mga korporasyon, ang mga public utilities, ang mga generation companies, ang mga distribution utilities all over the country, suportado ng gobyernong negosyo ng mga sektor, then, Mr. Chair, yun siguro ang tunay na pag-unlad. Hindi yung ang pagkuha ng mga foreign investors na para sa akin, secondary engine of growth. So, in summary na lang, Mr. Chair, sabihin ko siguro na, kung gusto nating umunlad ang buhay ng mga Pilipino, meron po mga problema ang mga Pilipino, katulad ng kontraktualisasyon. Katulad po na ang ating mga magsasaka ay walang lupa, di na kumpleto ang agrarian reform, may korupsyon. Pag isolve po natin to, i-address po natin to, uunlad naman ang buhay natin without chacha. Pero, kung hindi natin ma-eliminate ang kontraktualisasyon, kawalan ng trabaho, ang kawalan ng lupa ng mga magsasaka, ang korupsyon, walang mangyayaring pag-uunlad po sa ating bayan kahit 10 beses tayo magtsatsa taon-taon. So in the end, ang closing remark ko lang po, ang korupsyon at kahirapan ay hindi nagmumula sa konstitusyon. Kung kaya ang pag-amyenda dito ay hindi solusyon. Maraming salamat po, Mr. Chair.
Next, floor leader.
Mr. Chairman, I move that we recognize Attorney Joseph Angeles, board member of the Foundation for Economic Freedom.
The chair would like to recognize Attorney Joseph Angeles. Please proceed.
Good afternoon, Mr. Chairman. May it please the Honorable Chairman and members of the House of Representatives. Although the Philippines has before I begin, though I am a faculty member of the UP College of Law and have other affiliations, my statement should not be construed as positions taken by the foregoing organizations. Although the Philippines has recently liberalized foreign investment in public services and renewable energy, as evinced by amendments to the Public Service Act and amendments to the implementing rules and regulations of the Renewable Energy Act, we support the Congress's ongoing efforts to amend the Constitution for the following reasons. First, the Philippines is the only country in the ASEAN region where restrictions on foreign ownership, specifically on public utilities, are embodied in the Constitution, while its peers have them in legislation or policy. In Indonesia, Presidential Regulations number 49 of 2021 liberalized its economy by cutting foreign investment restrictions across many sectors, enabling greater foreign ownership in previously limited areas such as telecommunication, transportation, energy distribution, and construction services. In Malaysia, there is no blanket legislation that regulates FDI in various sectors. Instead, some sectors have sector-specific foreign equity restrictions. For example, in telecommunication services, 100% foreign ownership is allowed. In transportation service, it varies from 40% to 100%. In Thailand, 100% foreign ownership is permitted for electricity production, tap water production, industrial water, steam, container yards or inland container depots, loading, unloading facilities for cargo ships, and commercial airports. In the foregoing examples, the sectoral foreign equity limits are provided in legislative and executive policy, not constitutional provisions. Our foreign equity restrictions, which are entrenched in the Constitution, hamper the flexibility and agility of our policymakers to respond to evolving global and domestic economic needs and realities. Moreover, they tend to judicialize disputes that ought to be decided by duly elected representatives rather than by unelected magistrates. We understand that there are two main objections levied against these proposed reforms. First, there is no necessity for these constitutional amendments, given the enactment of the Public Service Act amendments and the Renewable Energy implementing rules. Second, that we should prioritize addressing other business concerns such as red tape and corruption. With your indulgence, allow me to discuss these points in seriatim. As regards the first objection on grounds of necessity, it cannot be denied that there are petitions pending before the Supreme Court challenging the constitutionality of the Public Service Act amendments. While we believe the PSA amendments should pass judicial scrutiny, these ongoing petitions engender additional regulatory risk, which our country can ill afford. The proposed constitutional amendments on public utilities will be helpful in obviating this uncertainty, as it may be considered curative legislation with judicial power limited to actual cases and controversies. Regarding the second objection on grounds of priority, it should be noted that the proposition implies a binary choice between reducing red tape and corruption and reducing hurdles to investment. This has been addressed by the study of Professor Fabella and his co-authors, as well as other literature, which predicts that reducing FDI restrictions will increase investment, ceteris paribus. In other words, we can walk and chew gum at the same time. It has also been argued that corporate control is irrelevant to foreign investors. On this point, I respectfully refer our honorable representatives to the extensive financial economics literature regarding control premiums, which indicates that investors indeed value possession of corporate control. Number two, supermajority voting requirements under corporation law for various important decisions, such as amendments to the Articles of Incorporation, increase or decrease of capital stock, or to incur bonded indebtedness, investments in other corporations or other businesses other than its primary purpose, and mergers. And may I also note, as mentioned earlier by the other resource persons, the heightened investor interest post-PSA and IRR enactments. To conclude, I wish to thank our honorable representatives for pursuing these landmark substantive reforms and for this opportunity to be of assistance.
Your leader.
Mr. Chairman, before we proceed to the next resource person, allow us to acknowledge the presence of our guests. Attorney Maria Corazon Hines, Director, Consumer Affairs Service. Mr. Sani Africa, the Executive Director of Ibon Foundation. Thank you very much, sir, for coming over. Dr. Gerardo Pizzicat, Professor Emeritus, UP School of Economics. Attorney Roberto Paig, Executive Director, LTFRB. Mr. Roj Ramirez, the representative of ANCAS. Attorney Marianina Gilbert, Corporate Attorney of Maynilad. Attorney Gilbert Bautista, the representative of PLDT. Attorney Kent Avestruz, representative of PLDT, and Mr. Orion Perez Dumdum, Chairperson, Correct Movement.
The chair would like to welcome our guest to the House of Representatives. Thank you for joining us.
Mr. Chairman, next resource person, may I move that we recognize Professor Solita Collias Monsud, Professor Emeritus of the UP School of Economics.
Chair would recognize Professor Monsud. You have the floor. Please proceed.
So, Professor Solita Monsod, Mr. Chair, may I move that she be recognized. May we request the Secretariat if Professor Monsod is here? But the invitation has been sent. Yeah,
okay, we'll move on to the next resource person.
So, Mr. Chair, whenever Professor Monsud will be available, she will be accommodated. For now, Mr. Chair, I move that we recognize Attorney Demosthenes Donato, President and General Counsel of Tanggulang Demokrasya.
Thank you, ma'am. Ma'am, we...
Please proceed.
Thank you, Mr. Chair. Ma'am, I'd like to inquire if the PowerPoint is ready. We also have 2 videos, 1 minute each. We requested the Secretariat. If it is not yet ready, ma'am, may request for a second call.
Tama.
Yan, ma'am. Ayan, ma'am. Thank you, Mr. Chair, for giving us this opportunity. Magandang hapon po sa inyong lahat. This is an excerpt of a longer PowerPoint. This is focused on the economy only. But before I go to the PowerPoint, if I may request the Secretariat to show the video. 1 minute video po.
Please proceed with your 1 minute video.
That's a separate link po. If it's not yet ready, Mr. Chair, then I will proceed with the PowerPoint. Next slide, please. Our group, Tanggulang Demokrasya, is in favor of liberalization of foreign investments. Simple lang po yung basis namin, law of supply and demand. No ideology, just supply and demand. So why do we want to change the Constitution, at least in the economy part? This is the reason. This data is pre-pandemic. But I'm sure it has changed now, but the bottom line is the same. For example, we have like 5 million or less jobless people. If you multiply that with the lowest minimum wage, that's 1/2 trillion in 1 year, just to give them minimum wage. Okay? And there are those who are afraid of or wary of foreign investors. But if you look at the Philippine population, 10% is overseas. Oh, they leave the country. Why? I think my colleague here calls them economic refugees. Yun lang naman po ang main reason why they leave the country, para maghanap buhay. And then again, no, yung sa foreign investments, number 1 foreign currency earner is OFW. Saan po ba kumukuha ng pera yung OFW? Sa foreign employer, in a foreign land, under a foreign government. So kung dito ho sila, we are in a better position to protect them. Yung number 2 dollar earner, what is that? BPO. These are mostly foreign owned. Yung data na po yan, we have sources for that we can share. Next slide, please. Yan, ito yung state of the economy. Slowest internet, highest power cost, water shortage. Next slide, please. Domestic shipping, mahal. Mas mahal pa mag-ship sa overseas sa Taiwan kaysa sa Philippines. Ito po, construction, pickup. This one I requested specifically from Dole. Yung pickup po kasi, they impose this 60-40 even if there's already a Supreme Court decision against it. May SEC opinion, wala siya sa foreign investment negative list, meron pang Supreme Court decision, but until today, they impose 60-40. So, what's there to protect? Maayos ba yung construction natin, industry? This is pre-pandemic data. Galing po sa Dole, I have the official letter with me. Yan po, 73% violations, 56% safety. So, is that the industry that we would like to protect? Next slide, please. Ito po. Simple lang po kami yung sa amin po, if we mix ideology with the economy, that will not lead us to a good result. Simple lang po, low supply and high demand. Mahal po yung pamumuhay, consumer goods. Next please. High supply, low demand, trabaho. Ayan. Kung wala hong trabaho, walang negosyo, walang trabaho, ay talagang yung nag-aagawan yung worker sa mga job posts, wala ho talagang mangyayari. Next slide, please. This is what I was saying. When we talk about amending the Constitution, it is not just the law. Ang experience ko po, no, dyan, because I do corporate work, M&A, foreign investment regulation, that has resulted into a negative mindset. Yung mga iba-ibang government agencies na kausap namin, akala nila lahat ng negosyo 60-40. So yung aside from the law itself, nag-ano na siya that has been there for what? 80 plus years? 1935 pa po yan. So yung marami ho, hindi ho nagbibiro, marami hong government agency, wala sa batas, pero kung kausap mo yung mga tao doon, 60-40. Yun, ito po yung isa po, yung pickup. Next slide, please. TESDA. Again, this is a personal experience po yan. A long time ago, we had this Japanese investor. Sabi sa akin ng mga business consultant, ano daw yun? That was the Japanese equivalent of Oracle. Yung chairman, yung matanda, gustong pumunta dito, ititrain yung Filipino engineers in Japanese language. Kasi yung trabaho nila doon, okay, engineer kayo, but you have to do your work in Japanese. So they went to TESDA, and TESDA told them 60-40. Ayun. So umalis na yung umalis na yung kumpanya. So I was talking to the consultant again, sir. Gawin natin ng paraan, meron naman yan yung mga restructuring. And then he just told me, Dindo, if the Philippines is the only country that can provide engineers, we will follow what you say. But you see, they can always go to Vietnam. Ayon. End of story. Next slide, please. Ito po, sinasabi dapat i-address yung corruption. Yung foreign investments po, that can address corruption. In what sense? Ito po, government procurement. Sa alam ko po, no, yung sa alam natin yan, makakilala na yung mga iba-ibang supplier dyan, pati yung mga SBAC sa Bids and Awards Committee, makakilala na rin. Everybody happy, nobody will talk. So how do you confront that? Sa amin po, di pasukan natin ng independent player. Sabi yun nung I read in a World Bank article before, this is based on their experience worldwide. In government procurement, if all the bidders are from the same country, the probability of corruption is higher. So, paano? O di pasukan natin ng ibang player, yung hindi nila kasama. Next slide, please. Ayan. Ito po yung suggestion namin. If we really want to develop the Philippine economy, let's not focus on citizenship. Let's look at the flag law. In fact, there are bills that want to amend the flag law, repeal it, improve on it. Ang basis ho sana, kung if we should give preference, is that their factory should be here. Hindi na mahalaga yun kung foreign-owned or local-owned. Ang mahalaga, nandito yung factory. Kasi kukuha yun ng worker, supervisor, manager. Let's leave the senior executives to them. Kanila namang pera yun. But if the factory is here, then okay. That's how to make sure that these investors will benefit the country. Next slide, please. Ayun po. Base sa nakita namin, there are two options available. I think what you have here in the RBH7 is the legislative option. Next, please. You add a clause unless otherwise provided by law. The other option is, yes, please, delete option. I recall correctly, this is from an article of Alex Magno. Sabi niya, if you want to liberalize, just delete. Para hindi na tayo magdebate sa language. Delete, 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 delete. Kami po, ang gusto namin delete. Bakit? Kasi po yung legislative option, remember po, we are bicameral. So if we pass a law, you need 3 approvals. House, Senate, BICAM. So yung unless otherwise provided by law, that will take us another 5 to 10 years. So yun po yung sa amin. Yun yung position lang po namin. Mas gusto namin yung delete option. I-delete na lang yan, and then those who want to protect their investments, let them lobby. Next slide, please. Yan po, example lang yan. What's the delete option? And then, next please. Yan, ang delete option. Just delete. O deliberalize na. But of course, that depends again on the city. Yun nga yung problema po eh. BICAM, may House, may Senate, may BICAM pa. Next please. Another option. This is not part of the topic today, but I was thinking and hoping there's another sector that needs liberalization, yung sa natural resources. Sa tingin ko lang po siguro marami mag-object. I'll just explain. No? For example, offshore oil drilling. Maliwanag naman po, walang Pilipino na marunong yan. Wala tayong, maaaring mga Pilipino may pera, pero wala silang experience, wala silang technology. If you go for offshore oil drilling, you need a foreign partner. Now, if you have this 60-40, anong role nung 60-40? Middleman. Di ba? Why don't we just allow the government to enter into direct contracts with whoever can give us the best terms and conditions? Otherwise, magmi-middleman lang po yan. Anyway, that's not part of the topic today. Siningit ko lang po. Next, please. Ayan po. Delete lang. Next, please. Ito po. We are aware of the concerns, no? Foreign cartel, foreign government, foreign domination, etc. Meron po kaming suggestion on how to address this risk. Totoo naman yung risk na yon. There is this US law, FINSA, Foreign Investment and National Security Act of 2007 or 2008. Yan po. Sa kanila po, walang blanket prohibition. Kasi hindi naman lahat ng foreign masama. Meron namang mabuti dyan. So, what they have is a committee that will check. They actually, how would they call it? Expelled Smartmatic in the US using that law. Or that initially, that was just an executive order. Later on, it became a law. They have this committee headed by the mga department secretaries. So, if, for example, if the concern is food security, ang mangunguna po dyan, di yung agricultural secretary, but the overall chairman is the Secretary of Justice. Ngayon, kung merong external threat, then of course, DND, kung local crime, yung DILG, etc. So, meron po. Actually, meron na po kaming nakasulat dyan on how it is crafted. That's where the people's draft comes from. Yun po yung side comment lang po, no? Yung alam natin na yung maraming kumukontra. Ang may experience po ako dyan, yung sa Sigaw ng Bayan, I was the Council of Lambino then. Ang pinaka-kontra ko nila dyan is yung fear of the unknown. Yun po. Kasi hindi alam ng tao kung ano yung susunod eh. So, if we only put out in the open what is it that you want, baka ho maibsan yun ng konti. Next slide please. I think that's the end. Meron ko sana akong dalawang video. I don't know if the secretary is able to show it. 1-minute videos lang po yun. It's an animated video. Sayang ho, maganda ho sana. Or maybe later, if that's possible.
From Secretariat?
If it's not available
you have
now.
the video? It's according to our guest, it's a 1-minute video.
It's on the internet po. I provided the link.
Do we have it, I don't. It seems that our secretariat doesn't have the video. Okay. It seems the secretariat cannot open the video.
Maganda sana yun, animation.
Floor leader.
Mr. Chair, may we request the Secretariat to play the 1-minute video via the link provided by our resource person, Attorney Donato.
Secretariat. The secretariat is hereby directed to play the video. Ba?
Mr. Chair, there is a security feature in the video. May I request for 1 minute suspension?
Hearing is suspended.
Mr. Chair.
Floor leader.
Mr. Chair, with the kind understanding...
Hearing is resumed.
Thank you, Mr. Chair. With the kind understanding of our good resource person, he has acceded that we will play the video at a later time and has likewise concluded his presentation. With this, I move that we recognize Mr. Orion Perez Dumdum, the chairperson of Correct Movement, for his presentation.
The chair would like to recognize Mr. Orion Perez Dumdum, chairperson, Correct Movement. Please proceed.
Thank you very much, Mr. Chair, and to all of the members of this House. My name is Orion Perez Dumdum, and I am a longtime former OFW based in Singapore. I only recently came back on the 14th of January. I actually have a presentation. I don't know if they were able to receive it. Would they be able to put it up? Anyway, I will just proceed in my introduction. So I co-founded the Correct Movement as a means of informing, educating, and enlightening fellow Filipinos using the internet and social media to get more Filipinos to understand the urgent need for constitutional reform. We actually started the Correct Movement back in 2010, and we've been continuing to educate and enlighten more and more Filipinos about why we need constitutional reform to happen. Why the Philippines needed constitutional reform long ago. It is actually, I might as well share my own personal experience. As an OFW, having lived in Singapore for a very long time, one of my biggest issues as an OFW was how can the Philippines be more like Singapore? That was always a question I was asking. And as I did my comparison between Singapore and the Philippines and other countries in the region versus the Philippines, I saw with my own eyes the reasons why the Philippines was essentially unable to do what Singapore and these other countries have done. It's unfortunate because our constitution is rigid and it is very restrictive against the entry of foreign direct investors. We have a constitution that blatantly tells foreign investors that they are not welcome. And then, just below that level, we have legislation that tries to ease that tries to make exceptions or exceptions to the rule that would somehow permit certain sectors to be opened. By that time, though, other countries would have decided not to look at the Philippines anymore because the moment they saw that the constitution of the Philippines, when compared to the constitution of other countries in the region, is the only one with anti-foreign direct investment restrictions, we automatically get removed from the shortlist. They no longer need to look at our special legislation that allows certain foreign investors to come into certain sectors. They don't care anymore. Natanggal na tayo sa listahan dahil sa konstitusyon natin. Dun pa lang tanggal na tayo. That is the unfortunate fact, that's the unfortunate reality, and as an OFW who has come in contact with numerous high-ranking people in headquarters based in Singapore for so many different companies, I found that to be totally true. Okay? Can I check now if my presentation is available? Can it be shown on the screen?
Secretariat, can you flash the presentation of Mr. Dumdum on our screens?
Is it available? If not,
Secretariat, who controls the screens?
yeah. Hello, I sent it to committeeonrules@gmail.com. So whoever is handling that could probably check it out.
Okay. Yes, please play the presentation of Mr. Dumdum. Do we have anybody there up in the control room, Secretariat? Can you please check?
Anyway, I will try to get straight to the point. Regarding resolution on both houses, number 7, our position in the correct movement is that we do not think that just simply adding unless otherwise provided by law will actually really help very much. It will help somewhat, but not very much. And that the only thing that we really need to do is to actually delete all of the anti-foreign direct investment restrictions in the Constitution. And that includes Article 12, Section 2, which is about resource extraction and production sharing. Article 12, Section 10, which is the general 60-40 clause hanging over every sector. The Article 12, Section 11, which is the Public Utilities 60-40 clause. Article 12, Section 14, Paragraph 2, which is about the practice of professions being limited to Filipinos only. And also the Article 14, Section 4, Paragraph 2, which is the 60-40 for education. The Article 16, Section 7, Paragraph 1, with the ban on foreigners owning media. And the Article 16, Section 11, Paragraph 2, which is the 70-30 restriction for advertising. It is our position that all of these must be removed. And if we need to have any form of restrictions or regulations, then we put these purely in legislation alone. That way, at least as a legislated reality, it's something that can be more easily changed. All right, if everyone can see the screen, this is the correct movement. We stand for constitutional reform and rectification for economic competitiveness and transformation. And we are pushing for 3 different things. The main one is economic liberalization, which aims to bring in more job-creating foreign direct investors to come to the Philippines, create jobs, help to solve our unemployment problem, help to solve our poverty problem, and make it easier for OFWs to eventually come home. OFWs like me, because I was an OFW until recently. And then because we also need to make sure that the opportunities, the job openings that are created by the removal of the anti-foreign direct investment restrictions do not happen only in Metro Manila. We want these to be spread out to the rest of the regions and provinces. We therefore want to have evolving federalism.
Mr. Chairman?
Yes.
Mr. Chairman.
I'm almost done.
Representative Rodriguez.
We cannot go now into the other advocacies of correct.
Yes, that's okay. I'm
so
almost done.
we have heard that our distinguished resource person is for opening up really all the those prohibitive and provisions limiting. So we cannot talk about federalism, we cannot talk about parliamentary government. Otherwise, we will be misunderstood. And the Senate will misunderstand us. That we might want to abolish them. Thank you very much.
Okay.
So can we just go to a summary of economic amendments?
Yes, yes. So just to show that screen again, that is just me explaining what the correct movement is about. So at this particular juncture, we know we do not have time to explore the federalism and parliamentary system because these are more complex, very complex reforms. Economic liberalization is easy. Just delete, remove, take out. Yun lang. Tatanggalin lang ang mga mali. Yun lang. Nothing to replace. Tanggal lang, delete lang. And that's it. And we have time for that because obviously we know that next year is going to be an election year. And by October of this year, people will be more focused on the elections. So again, do not just add unless otherwise provided by law, but actually delete all those following phrases. All right, so next is, let's talk about the Philippines and FDI. So, unfortunately, let's go to the next one. Okay, there was a group that presented some slides which unfortunately showed some misrepresentations, and I think that was pretty well done by Congresswoman Stella Kimbo, who did a great job in exposing the misrepresentation that happened there. Let's move to the next slide. The misrepresentation was this slide, which aims to show that the Philippines is most open, when in fact, we know that this is not really true because of the constitutional restrictions, which are merely being circumvented by legislation. As we know it, though, mere legislation cannot truly trump the constitutional restrictions. And therefore, in reality, let's move to the next slide, this is the reality that we have. We are like that. That is the reality of the Philippines. Not the green ones that the Ibon Foundation was trying to misrepresent to everyone, including the people in the Senate. All right, let's move to the next slide. All right, if you can see here, all these other countries basically have this very clear message that you are all welcome. They are telling foreign direct investors that you are welcome because in their own constitutions, they do not have restrictions against them. And then they have the so-called fine print. I made this deliberate. If you see the small black print below, that's deliberately made so small that you cannot see it. You have to go near to be able to read it. But from this distance, all you can see is the big text. You are welcome. No restrictions. When you look at the Philippine situation, you look at the Philippine flag, below that, it shows you aren't welcome. Foreign direct investors are restricted in the Constitution. And then we have small fine print, which so-called allows investors to come in. This, however, is fine print that can still be questioned as to its constitutionality by the Supreme Court. And we know that this has happened many times. Okay, let's move to the next slide. All right, key points. The Philippines is not the least restrictive to FDI in the region. It is the most restricted to foreign investments in the Southeast Asia region and within East Asia. The Philippines remains consistently among the top of the rankings for foreign investment restrictiveness globally since the measure and indices started. The restrictions in the Constitution prevent the Philippines from reaping the benefits of FDI. And a lack of FDI creates joblessness and other pressing social issues. Social issues such as the proliferation of OFWs, many of whom are no longer with their families. We have social costs related to that. So many breakups of families that happen. And I know personally so many OFW families that have broken up. And this is why I'm very angry that we continue to just think that being a provider, allowing people to go abroad is just the way, okay na yan. Let's bring the jobs into the Philippines instead of having to send our people abroad. Tapos pag uwi ng iba, nasa kahon na. Di ba? Move to the next, please. Okay, terms. Total FDI restrictions. If we're going to look at the graphs, there's basically the foreign equity restrictions or foreign ownership restrictions, and there's other things as well. Move to the next one, please. According to the OECD, the effect of reducing foreign equity restrictions is the strongest, denoting its relatively greater importance as a statutory barrier for investors. So those people who claim that reducing or removing foreign equity restrictions doesn't do anything are wrong. Probably they're wrong or just don't know, or probably they are liars. Let's move to the next, please. As you can see here, if it was clear to everyone, that we are third on the list for the 2020 OECD FDI restrictiveness. We are only beaten by the Palestinian Authority, which is right next at number 2, and at number 1 is Libya. We are number 3 worldwide, ladies and gentlemen. Move to the next, please. And this is the true state of the ownership restrictions, not that one that Ibon Foundation actually showed last time. This is the reality. Look at the first one, that's us. The one with the most reds and oranges. That's us. Tayo ang pinakamaraming restriction. All those others, yan, Singapore is the one at the very right, yan yung pinaka-least restrictive. Okay? So yan ang reality. Next. Restrictiveness on FDI in the Philippines are high by both regional and global standards. Foreign equity restrictions exist in many non-manufacturing sectors. Many restrictions are enshrined directly in the Constitution rather than in an investment law or sectoral legislation, with the result that reforms have proved very difficult to enact. By the way, many of you might be wondering, why is it that despite being open to manufacturing companies, we are not able to bring in as many manufacturing companies as possible? Why? Because in today's age, the manner by which companies, manufacturing conglomerates, locate their operations abroad, they do not do so via singular entities. Hindi siya mag-isang, si Apple Incorporated, Apple Computer, papasok sa isang bansa, siya lang mag-isa. Hindi. They come in through an entourage arrangement, meaning to say, Apple comes in, and then it brings in Foxconn, its contractor. It will bring in probably Deloitte & Touche, its auditor and accounting provider, and all these other ancillary providers of services that come along with it. And some of those companies that come along with the entourage are not allowed by our restrictions in the FINL and FIRL, Foreign Investment Restricted or Negative List. When there is one member of the entourage not allowed, the whole entourage will not come in. Yun po ang nangyayari sa Pilipinas. Kawawa tayo. Okay, next. All right. So what do we want to do? Well, if you look at the left side, we have our economic restrictions in the Constitution, and then in the legislation, we have additional economic restrictions and permissions. What we want to do is to remove all economic restrictions from the Constitution and move any required or necessary restrictions or regulations to legislation or policy instead. Yun na lang. Next. We have a losing battle for jobs, opportunities, and development. Indonesia and Vietnam are winning the competition for foreign investors.
Mr. Chairman, with due respect to Mr. Dumdum,
Representative Rodriguez.
It's already been 4 minutes. I thought it's a 1-minute video. So can we just ask our good chairman and founder of Correct to wind up?
Okay.
Because
Yes,
we still
the
have
chair
many
would
guests.
like
Thank
to
you.
ask our resource person to kindly wind up, and a reminder to all our guests and resource person to refrain from trying to mention the presentation of another resource person or guest. Please proceed.
Noted. All right. I know that there have been other people who've said that investors don't really care about the restrictions, but actually we all know that the Joint Foreign Chambers of Commerce and Industry are themselves representing companies that have tried to invest in the Philippines, and they have repeatedly come here to this August hall, and both this hall and the one in the other side at the Senate. They've repeatedly said that they want them out. They've repeatedly claimed and said that these restrictions are very discouraging to the companies that come from their countries of origin. I think that is essentially what I wanted to say, that these restrictions have to go. any mention of, no, it's not really necessary, oh, no, it's not the direct cause, oh, it's actually electricity that's the real concern, it's just another form of, wag na nating gawin. And that's another way of basically saying, wag na lang nating paunlarin ng Pilipinas. Because ultimately, if we look at the root causes of our problems, pati yung electricity, nasa restrictions din yan eh. If we had been more open in the transmission side to foreign investors, we might have had more high quality and more advanced technology that would allow us to have more efficient energy distribution, leading to lower energy costs. Ganun lang kasimple. But of course, sasabihin lang yung what you call this, the proximate cause. Oh, they don't like it because they don't like the Philippines kasi mahal ang electricity. Pero ayaw nilang tingnan ang root cause bakit expensive ang electricity. Makikita po natin yung mga kababayan, ang problema talaga ay nasa konstitusyon natin, nasa saligang batas. Kaya baguhin na po natin ang saligang batas, tanggalin po natin. Let's please delete all anti-foreign direct investment restrictions. This is coming from an OFW who has seen a lot of the problems caused by this. I've seen so many breakups of families and all that. I don't want to see any more of that. Thank you very much.
Okay, floor leader.
Mr. Chair, I now move that you recognize...
Mr. Chair, point of order lang. Mr. Chair, sa presentation kasi kanina ng resource person from Correct Movement, meron po siyang slide na nire-red tag po ang kapwa resource person din, which is Ibon Foundation. Mr. Chair, we believe these sessions should not be a platform for one resource person to red tag another. Kaya Mr. Chair, I appeal to this committee na hindi i-include sa records yung presentation ng Correct Movement unless tanggalin yun. Kasi Mr. Chair, nakakadungis po yun sa proceedings natin na may mga ganong discredit sa ating mga resource person na hindi batay sa nilalaman ng kanilang mga arguments.
Yeah. Mr. Chair, we duly take note of that, and for the information of our good colleague, I have approached the good director, Mr. Sani Africa of Ibon Foundation, and he will be given time to present the side of the basis of the presentation. With that, Mr. Chair, allow me to put forward a motion to move that we recognize the Honorable Justice Antonio T. Carpio, former Associate Justice of the Supreme Court of the Philippines.
The chair would like to recognize Justice Antonio T. Carpio. Please proceed.
Thank you, Mr. Speaker, and your honors for this opportunity to address in my personal capacity the Committee of the Whole. First, I agree that under the first mode of changing the Constitution, as stated in Section 1, Paragraph 1, Article 17 of the 1987 Constitution, the House and the Senate can meet separately and vote separately by 3/4 votes of all the respected members to propose amendments or revisions to the Constitution. The reason is obvious. This provision of the Constitution expressly states, and I quote, Congress, upon a vote of 3/4 of all its members, end of quote, may propose amendments or revisions to the Constitution. The Constitution uses the word Congress and not Constituent Assembly. The term Constituent Assembly does not appear anywhere in the Constitution. The Constitution further states, and I quote, Congress shall consist of a Senate and a House of Representatives, end of quote. Thus, the act of the Senate alone is not the act of Congress. The act of House alone is not the act of Congress. Both must approve separately an act before the same act can become an act of Congress. Under the first mode of changing the Constitution, which is the mode that this House is undertaking right now, the Constitution expressly requires Congress itself and not any other body to propose amendments or revisions to the Constitution. Unless otherwise expressly provided by the Constitution, Congress is a bicameral body, and each chamber must approve an act separately before an act can be considered an act of Congress. There is only one instance when Congress is expressly directed by the Constitution to vote jointly, and that is when Congress automatically reviews within 24 hours the President's declaration of martial law or suspension of the privilege of the writ of habeas corpus. In all other cases, the two chambers of Congress vote separately because Congress is a bicameral body. We must follow what is so obviously, clearly written in the Constitution as required by the verba legis rule. Second, the Philippines has already one of the most liberalized investment laws for foreign investments in ASEAN and in Asia. The recently enacted amended Public Service Act is largely the reason for this. Thus, the law foreign direct investments in the Philippines cannot be blamed on our investment laws or the Constitution. Our high power cost, bureaucratic regulations, absence of rule of law, and poor infrastructure are to blame for the law foreign direct investments, not the Constitution. Third, if Congress is still minded to amend the economic provisions of the Constitution to make it easier for Congress to later on liberalize further the economy to attract more foreign investments, then I propose that the amendment should read as follows, and I quote, "Unless otherwise provided by law, subject to reciprocity and two-thirds vote of all the members of the Senate and of the House of Representatives," end of quote. Reciprocity is already required in Section 25 of the amended Public Service Act. Reciprocity is fair and equitable to Filipinos and foreign investors alike, because if we open our public utilities and other industries to 100% foreign ownership, Filipinos must likewise be able to own 100% of the same public utilities and industries in the countries of these foreign investors. Moreover, since the amendment authorizes Congress, by enacting ordinary legislation, to amend constitutional provisions that reserve certain industries to Filipinos, a higher voting requirement than that required for enacting ordinary legislation should be imposed. Thus, a two-thirds vote, higher than the simple majority, but lower than the three-fourths vote presently required in the Constitution, would be reasonable. Further, the constitutionality of the amended Public Service Act is presently being challenged in the Supreme Court. The most contentious issue, in my opinion, is who is the final arbiter of the term public utility, as this term is used in the Constitution. Congress or the Supreme Court? Congress has interpreted in a law the term public utility. If Congress can enact a law interpreting words or phrases as used in the Constitution, then Congress is the final interpreter of the Constitution and not the Supreme Court, divesting the Supreme Court of its constitutional duty as a final interpreter of the Constitution. As a fail-safe measure, in case of an adverse decision by the Supreme Court, Congress should proceed with the proposed amendment to the economic provisions of the Constitution to cure any defect in the amended Public Service Act. Fourth and lastly, I believe that primary and secondary education in our country should remain in the hands of the state and Filipino citizens. These are the formative years of our youth. However, we can allow foreigners to own up to 50% of our educational institutions at the collegiate level, since we need the expertise and specialized skills of foreign experts at the collegiate level. For graduate studies, we can allow 100% foreign ownership by world-renowned educational institutions, instead of sending our graduate students to study abroad in these very expensive institutions. These are my humble comments, Your Honors. Thank you for your kind attention.
Thank you, Justice Carpio. Floor leader.
Thank you, Mr. Chair. Our next resource person is Attorney Christian Monsod, former chairman and former member of the Constitutional Commission. I therefore move, Mr. Chair, that we recognize Attorney Christian Monsod.
The chair would like to recognize Attorney Christian Monsod. Please proceed.
Mr. Chair, allow me to amend my motion. Considering that Attorney Monsod is not yet in the plenary, may we just remind the Secretariat to please send the invitation or to resend the invitation. With that, Mr. Chair, I move that we recognize Dr. Gerardo P. Sicat, Professor Emeritus of the UP School of Economics.
The chair would like to recognize Dr. Gerardo P. Sicat, Professor Emeritus, UP School of Economics. Please proceed.
Thank you, Mr. Chairman. I did not plan to be called. I did not plan to be a speaking resource person today, but I am forced because I am put in the agenda. I welcome being called. Thank you very much. The only remarks I want to say are the following. They are relevant to the issue at hand today, which is really on public utilities. But my comments will be framed in a more general framework, because just looking at public utilities as the example, they are the critical components of services rendered within a country for dealing with all kinds of economic production within the country. I do not know why in 1935 our forefathers decided to say it should only be Filipino. I think it was a mistake in foresight on their part, because they did not know that when America began investing in public utilities for us, every Filipino became part of that progress. Historically, this is true for many of the services tied up with public utilities. In the 1930s, we were the most, I think, the most advanced colony within the Southeast Asian region of any Western power, probably except Hong Kong and Singapore, because they were very small entities, and they were really a bastion of free trade. So everybody could participate in the production of anything, including the provision of public utilities. You see, the English, they were smart colonizers. They were smart colonizers because they just, to maintain progress within the country that they were running, they were controlling, they just allowed free trade to come in. And so the kind of influence it had, I mean, British colonialism had on Singapore and Hong Kong became a persuasive argument for just demonstrating that what they had done was to free the economy from all these kinds of micromanagement of people who think they know better. And I think our forefathers began thinking, we must own the Philippines. We will become independent. So what did we do? We decided we must control this and control that. It's interesting that when we got the Constitution brought before the U.S. President, he signed it off. I was wondering why he did, but we know, as the past experience had given us, that America would not allow that because they had interests that were in the country that could not just be wiped away because they gave independence to a colony. But do you know what they did for us? They were foreigners from our viewpoint. And our forefathers, our constitutional builders said, we must exclude them in time. That was, I think, the first wrong insight, because those public utilities were not introduced, and the services in transportation, shipping, electricity, communications, and so on, if they did not go on to be there, we would probably have been unable to secure our independence because we would have become ignorant still. But compare this with what the British did. Everybody could import and export, everybody could participate. Even, you know, I was reminded in Jose Rizal's essay, The Philippines, 100 century, 1 century hence, or something like that. I've forgotten the exact title. I think you should forgive my age. What he said basically was that Hong Kong is a small island, but it had a lot of good management. It had, basically, he was really praising that Hong Kong, in his time, was a bastion of economic freedom. And I think it explains to some extent why he spent some of the time in exile in Hong Kong. But that's beside the point. But the other point, of course, with Rizal was that he tried to encourage, in fact, his own group to set up somewhere in Borneo, to immigrate and create a colony of Filipinos, because he felt that they would have economic freedom to set up. I'm citing these small bits of history because the main problem we have today is that we are still colonized by that colonial thinking of the past. We must free ourselves of that. I agree that probably why Hong Kong and why Singapore as a country is the most advanced country in Southeast Asia was that it did not have to bother with all these kinds of framework. They just followed, Lee Kuan Yew just followed the fact that when Singaporeans are in control, they control the country. And so they could undertake any legal judgment, any passage of laws, because Singaporeans control the country. But they did not have fundamental laws here and there that restricted them from doing anything, because from doing certain things, because they were not prevented by fundamental laws that restricted them from undertaking controlling the way the economy had to be micromanaged. I don't know whether I have traversed beyond the point of our discussion, but the main point is that all of the things that they do in economic matters in Singapore, in Indonesia, in Thailand, are things that they can do by legislation. They have no fundamental law telling them what to do on particular items. They do that, they control those things by setting them through the legislative process of the people who are elected in their own chambers. I think this is the kind of ideal we should follow. There was a mistake of our forefathers. We correct it. The best way to correct it is erase what they did and free our economy. Thank you very much.
Mr. Chair,
Florida.
I now move that you recognize Attorney Maria Corazon Hines of the Consumer Affairs Service.
Good afternoon, Mr. Chair. Good afternoon to the honorable members of
Please
Congress.
proceed.
I'm representing the Energy Regulatory Commission, Your Honors.
Mr. Chair, apologies for that. Attorney Maria Corazon Hines of the Energy Regulatory Commission, ERC, Mr. Chair.
Okay, please proceed.
Thank you, Mr. Chair. Again, good afternoon, Your Honors. In behalf of the Commission, we would like to convey our no objections to the to resolution of both houses number 7, and the Commission would like to convey that we will defer to the wisdom and knowledge of the members of the House of Representatives with respect to this proposed legislation. If you will need any data or information under the jurisdiction of the ERC, then we would gladly provide such data and information. Thank you, Your Honors.
Mr. Chair, I move that we recognize Attorney Roberto Paig of LTFRB, the Executive Director. Attorney Paig.
Attorney, Floor Leader.
Attorney Paig.
Good afternoon, Mr. Chair.
Okay, please proceed.
For the LTFRB, Mr. Chair, with the enactment of Republic Act number 11659, the LTFRB, through our Franchise Planning Monitoring Division and Legal Division, is currently crafting its position paper on removing the nationality requirement for applicants of Certificate of Public Convenience to operate land-based public utility vehicles. It is, however, noted that RA 11659 removed the nationality requirement for TNVS operators. It is then respectfully requested, Mr. Chair, that LTFRB be given ample time to fully craft our position paper vis-a-vis improvement of public service quality that will redound to the benefit of our commuters and other stakeholders. Thank you, Mr. Chair.
Floor Leader.
Mr. Chair, I now move that we recognize Mr. Sandy Africa of Ibon Foundation.
The Chair would like to recognize Mr. Africa of Ibon Foundation. Please proceed.
Magandang hapon, Mr. Chair. First po, apologies for not being able to attend yesterday. Nagkaroon kami ng konting confusion. Akala ko either Monday or Tuesday. Monday pinili ko. Hindi ko lang both days pala. Pero best effort naman to appear now. Regarding siguro yung matter at hand of the public utilities, we fully support yung concerns of former Rep. Colmenares na opening up yung utilities really will adversely affect the public service character of public utilities. We think that yes, it is possible to make gains from foreign direct investment, the expertise, the capital, but we think it's also more important to look beyond the short-term gain. Kasi hindi lang naman yung pakinabang yung immediate service. Ang sanang long-term gain natin is yung long-term capacity na eventually yung Pilipinas ang makikinabang from its own resources, from providing that service. And I think kung di ma-capture yung point na yon, we'll get stuck in a chronic dependence on foreign technology, which means foreign payments, which means also yung na-raise ni Rep. Colmenares about yung national security considerations. We think right now, again, to repeat what we said on Monday, we completely oppose the proposals to open up the charter. We think it's very dangerous, especially, which we wanted to stress, given yung dominant thinking, medyo may foreign investment fetish tayo eh. Parang ina-assume talaga na magic bullet siya. Itong obsession with foreign investment, na ikatutuwa natin basta dumaming foreign investment, it leads unfortunately an obsession with very short-term metrics for development. And I think if we start the discussion about foreign investment, balikan talaga natin ano yung long-term naging pakinabang sa foreign investment over so many decades of the economy opening up. Tingin namin napakahalaga while we need foreign investment to help Philippine development. Yung prior need doon ay hindi usipin na pagbubukas. Yung prior need doon is, again, as nabanggit ni Representative Colmenares, kailangan may balangkas for making sure foreign investment helps national development. If it doesn't help build capacity in public utilities, if it doesn't help build capacity in industrialization, if it doesn't help build capacity for the economy to benefit from its own natural resources, from its labor, maging address lang tayo for foreign capital. And I think, doon ako nagtataka eh. Hindi ba natin na-realize ang kinatutuwa ng mga foreign powers, yung national brands. Ba tayo matutuwa tayo na address tayo ng kumpanya dito? So parang napaka-captive natin sa colonial mentality na imbis na ikatuwa natin yung kakayanan ng Pilipinas to stand on its own, to have its own national enterprises, I think weird na ikatutuwa natin na porking address ay an expert zone in southern Philippines or in southern Luzon, medyo may problema doon. Specifically dun sa usapin ng foreign ownership and utilities, actually, I will refer then to yung na-flag na naman na infographic ng Ibon ng isang araw at na-raise ang isang kapwa resource person namin. Maganda actually tingnan natin, ano ba yung comparable foreign ownership in utilities sa region. And we have to assert talaga, yung Pilipinas ay most open in the region, mamaya ako na i-correct yung pagpapanggap na pag-correct sa amin. We do want to clarify, kung titignan natin yung ownership sa utilities, yun nga, because of the Public Services Act, the redefinition, 100% open na. Basically, it's only electricity distribution transmission na 40%. I-compare yan sa Indonesia, again, sa aming pagtingin sa national investment laws from the UNCTAD Investment Policy Hub, in media, in telecommunications, may 49 to 67% restriction ng Indonesia. Sa power, may 95% restriction siya. Sa transport, may 49% restriction siya. Sa Vietnam, nakatingala tayo palagi, oo, pwedeng 100% foreign investment sa generation, but I don't know if many know here, yung distribution and transmission is a state monopoly. So hindi na sa bawal ang private investment. Actually, and so hindi na sa bawal ang foreign investment, bawal ang private investment in the power sector. In terms of telecommunications, it ranges 49 to 51% in Vietnam. In terms of transport, nag-iiba siya from 34 to 49%, depende dun sa particular sector. Sa Malaysia, yung telecommunications, sa 30 to 49% restriction. Sa power sector nila, 30%. Yung transport nila, pwede 100%. Sa Thailand, in general, 49% siya. And I don't know kung alam na marami dito, there's actually pending legislation in Thailand na hindi lang yung 40% ownership ng shares, ultimate ownership ang dapat covered by restriction, even mismo yung nationality ng mga directors. So kung yung direksyon nila, hindi pagluluwag, if anything, paghihigpit pa nga. And in that infographic, binanggit din namin actually yung sa China, pero sige, kung sabihin natin, sui generis not comparable, hindi. I also want to raise a concern dun sa misinterpretation ng Ibon infographic. Kami naman sa Ibon, handa kami palaging makorek. Pero kung makorek kami, sana makorek with something correct. Hindi kami makorek with something wrong. Sa amin, we welcome namin makorek kasi lahat naman tayo dapat matuto sa kamalian, magwawasto. Pero to be very clear, yung infographic na yon, ang starting point nun ay yung World Bank Investing Across Borders na report in 2012.
Mr. Africa.
Yes po.
Representative Paduano.
Yes,
Just a point
sorry.
of order, Mr. Chairman. The representative...
Secretariat, can we put on the microphone of Representative Paduano? Siyang mic natin.
Mr. Chairman, the representative from Ibon, Mr. Africa, has delivered his opening statement in the first hearing. Now, question of the presentation made by Mr. Dumdum. We do not allow resource speakers to have a debate in this committee hearing. Now, if Mr. Africa wants to refute such statement or presentation made by Mr. Dumdum, he should ask somebody from the members of the House leading questions to answer such accusations or presentation of Mr. Dumdum. That is not our procedure in this committee hearing, committee of the whole, Mr. Chairman. Second, Mr. Chairman, there is a manifestation of the good congressman from Kabataan Party List, and I thought of the why that is a motion to strike off the presentation made by Mr. Dumdum with regards to the presentation made by Mr. Africa in the previous hearing. Now, just just a point of clarification, Mr. Chairman, are we allowing resource person to have a debate?
They are
Because
not allowed.
that is not our procedure, Mr. Chairman.
Paduano, the chair already cautioned our guests to refrain from mentioning the presentation of other guests. I mentioned that a few minutes ago.
That is why, Mr.
So
Chairman,
to-
Mr. Chairman, just a few minutes. That's why, Mr. Chairman, following our procedure, we will not allow resource person to refute statements or presentation by another resource person. That's why I hope Mr. Africa understands, and the chair, I ask the chair that Mr. Africa should ask members of this committee to have a leading question to answer the statement or presentation made by Mr. Dumdum, Mr. Chairman, or the good congressman from the Kabataan Party List will move to strike off the presentation made by Mr. Dumdum questioning the presentation of Mr. Africa the other day. Thank you, Mr. Chairman.
Okay, the comments of Representative Paduan is noted by the chair.
Yeah, Mr. Chairman. Mr. Chairman, just to clarify.
By the way, the chair would like to ask Mr. Africa to finish first his presentation.
Yes, Mr. Chairman, just for clarity, the
Okay,
reason
floor
why...
leader.
Yeah, thank you, Mr. Chair. The reason why Mr. Sunny Africa was given time was for him to present the side of Ibon Foundation in terms of Article 12. Similar also to Attorney Nery Colmenares, who presented during the general concept, but was again allowed to present earlier due to general concept. So the motion earlier of Kabataan Party List, Honorable Manuel, to strike out of the records the presentation of a resource person from...
Correct.
Mr. Chairman, that is, just to correct the majority floor leader, that is not a motion. That is just an observation and manifestation made by Congressman Manuel. Now, what I'm saying,
Yes.
Mr. Chairman,
Okay.
do we allow now...
To expedite the proceedings.
Mr. Chairman,
Yes, Representative Paduano.
this is not a good precedent. If we allow resource person to refute statements coming from another resource person, because this will be a bad precedent.
Yes, the chair will not allow that. Please proceed. Representative Mr. Africa, would you continue your presentation? Okay, because we still have, how many more resource persons do we have on the list? Before we go on to recognize our members who wish to interpret.
We still have 3, Mr. Chair, and we are hoping to have 2 interpellators before the session starts. May I move that we recognize Mr. Sunny Africa to continue his presentation in terms of the proposed amendment on Article 12.
Just to manifest.
Mr. Chair, I move that we recognize Honorable Stella Kimbo.
The chair would like to recognize Representative Kimbo. You have the floor.
Just a short manifestation. I believe that this discussion began with my interpellation last night because Mr. Dumdum actually mentioned my interpellation last night. I had wanted to interpellate Mr. Sunny Africa. In fact, after his presentation last Monday, I asked Mr. Sunny Africa to appear the following day because I told him that I wanted to interpellate him. So I forewarned him that I had wanted to interpellate him. So he knew my intent.
Given that Representative Kimbo, you are more in a position to interpellate Mr. Africa than
correct. But given that
Mr. Dumdum.
Yes, but given that he did not appear. So I would just like to correct what he said earlier. Mr. Africa said that he said something to the effect.
Representative Kimbo, can we allow our guest to finish his statement?
No, yes, but I just want to say for the record that his not being here was unplanned or something to that effect. He was forewarned by me right after his presentation that I wanted to interpellate him, but he did not show up yesterday. So I just wanted to put that on record.
The chair will give you your time later to interpellate our resource persons, okay?
Thank you.
Would you wrap up your statement,
So, Mr. Chair,
Mr. Africa?
let me move again that we allow we recognize Mr. Sani Africa to finish his presentation insofar as proposals to amendments on Article 12 is concerned.
Mr. Africa, please proceed.
I'll repeat po my very first sentence. The invitation of the committee to the whole to me was for 2 days. When I asked for clarification, if I had to attend for 2 days, the committee in an email and a text told me I could only just attend on Monday. So to be clear po, when Rep. Kimbo approached me at the end of the Monday hearing, I had already had a prior schedule on Tuesday, which I did try to move, but I couldn't move. But I want to be very clear, if we had been told from the very start that the 2-day attendance was required, we would have done that. But when you asked for clarification, we were given a choice.
Mr. Africa, would you continue your statement,
Yes,
or done with your opening statement?
My final statement po, I think, I just want to be very clear. We are very open by not just a resource person. I will strike that off the record of my head. If there's any representative who needs clarification of the source of our data, we can present that. If it's a point of interpellation, we'll be happy with that. We just want to close with, we have no principal disagreement of foreign direct investment if the conditions are there. We think that for foreign direct investment to have any long-term gains to the Philippines, we have to have the right policy environment, we have to have the right institutions, and if we don't have the right policy environment, like industrial policy or a policy to develop Philippine utilities, like our neighbors have, letting foreign investment in is very dangerous. It will create a very adverse path dependence. It will actually create a sunk cost that we will be ever more beholden to foreign investment. So we strongly oppose any measure to open up the economy. We propose get our act in order first, get rid of the fetish for foreign direct investment. Thank you.
Okay, thank you very much, Mr. Africa. Floor leader.
Mr. Chair, I move that we recognize. Apologies earlier, I said Mr. Roach Ramirez. It's Ms. Roach Ramirez, the representative of Angkas.
The chair would like to recognize Ms. Roach Ramirez, representative of Angkas. Please proceed.
Good afternoon, Mr. Chair, Your Honors. Thank you for allowing Angkas to participate in today's proceedings. Preliminarily, we support the proposed amendments on certain economic provisions, particularly Section 11 of Article 12 of the Constitution. Consistent with the mandate on Filipino preference in business and trade, we think it is important to put local businesses in control of the motorcycle taxi industry, at least particularly in the beginning, so that Filipinos will be given the opportunity to run the platform where bikers can thrive. We support the requirement on 60% Filipino ownership, including for the issuance of licenses, including under the pending bills for motorcycles for hire, as this will put Filipinos at the forefront of the developing and growing motorcycle taxi industry. The Philippines is also currently seen as a strong contender in the startup scene, and we think that this requirement will help build an environment which is supportive of local startups who are engaged in tech entrepreneurship. On balance, however, we think that the motorcycle taxi industry can also be opened up to increase participation of foreign participants. And this can be done by eventually changing the requirement on, by eventually changing the nationality requirement. And this will be in view of equal opportunity, reciprocity, and to promote competition. This can be done after local businesses will be given sufficient period of time to tap into the Filipino market, serve their users, and this is all towards creating a sustainable and long-term development for local businesses. Mr. Chair, that's the position of Angkas. Thank you for your kind attention.
Thank you, Ms. Ramirez. Floor leader.
Mr. Chair, We have now exhausted all the resource person insofar as the proposed amendments on Article 12 is concerned. I now move that we recognize the Honorable Edsel Lagman of the 1st District of Albay for his interpellation.
The chair would like to recognize the Honorable Edsel Lagman. You have the floor. Please proceed.
Thank you, Mr. Chairman. Let me preface my interpellation by underscoring the following. One, let me caution the resource persons from invoking Republic Act 11659, amending the Public Service Act, because this is not yet effective. It is still in limbo because it has been challenged before the Supreme Court as being unconstitutional. Rightly so, Mr. Chairman, because in this Republic Act, Congress made a subterfuge of distinguishing public service from public utility, just to exempt enterprises provided for under public service to escape the citizenship requirement or nationality requirement in the Constitution. The Supreme Court has repeatedly held that the core element of public utility is public service. And public service and public utility are the same and interchangeable. So, since this is still a question before the Supreme Court, this is not a law which we should invoke in favor or against liberalization. Number two, when the Constitution referred to Congress under Article 6 on legislative department, the Constitution was referring to a bicameral legislative assembly which is authorized to enact laws. But when Article 17 referred to the Congress on the provision on the amendment or revision of the Constitution, Congress here was given a constituent authority to propose amendments to the Constitution. So, in other words, members of Congress exercising constituent power are not legislating. They are not enacting laws, but they are proposing amendments to the Constitution. So that distinction should be made, so that we could interpret the Congress in Article 17 as the traditional constituent assembly where representatives and senators meet to propose the Constitution in a joint session. Whether they will vote separately or not is a judicial question which most probably should be resolved by the Supreme Court in a proper case. And I would like to cite, Mr. Chairman, the ruling in Gonzales versus Comelec, where the Supreme Court held that when members of the Constituent Assembly meet, they are not legislating, but they're introducing amendments to the Constitution. So one member has one vote. They are not there as representatives or senators, but members of a constituent body. Thank you, Mr. Chairman, for allowing me to make this preliminary statement. My first question is, can someone give us a comprehensive definition on what is a public utility?
Mr. Chair, may I move that we request Undersecretary Sharon Garin to answer the question.
Mr. Chair,
if I am allowed so, Mr. Chair, I will answer this as a former member of the House defending the Public Service Act, in which we've had extensive debates with Congressman Etzel also. In the Public Service Act, it was actually defined, the public utilities were enumerated, and in addition to the enumeration, there was a definition of what it is. And in the Public Service Act, it was specific that the public utility, as differentiated from public services, includes distribution of electricity, transmission of electricity, petroleum and petroleum products, water pipeline distribution services and wastewater, seaports, and public utility vehicles with some qualifications. But in order to add or remove any of that under the public utility list, you can add or deduct by an act of Congress through the recommendation of NEDA that it has to follow certain parameters or criteria, in which there is one of the most essential is the service, availability of the service to the public, for the welfare of the public, but also on the monopoly, Mr. Chair.
I think we should not muddle the issue, because under the original Public Service Act, there was no distinction between public service and public utility. It was only under Republic Act 11659 where Congress made that distinction to exempt those categorized under public service from the citizenship requirement under Article 12 of the Constitution. Let me offer this definition from the Supreme Court. The Supreme Court held that a public utility as a business or service engaged in regularly supplying the public with some commodity necessary for the maintenance of life and occupation of the residents. As what our former colleague, Congressman Neri said, it is the lifeblood of the nation. These are the public utilities. Now, we know whether in other countries public utilities are nationalized or not? Can any of the resource persons answer this question? Otherwise, I will answer my own question.
We have Attorney Joseph from the Freedom of Economy, Foundation for Economic Freedom. May we request, Mr. Chair, that he be acknowledged to answer.
Attorney Joseph, you have the floor. Please respond.
Yes, Mr. Chairman. According to, as I mentioned earlier, let me pull up my presentation. It was mentioned that it was mentioned earlier that, for example, in Malaysia, 100% foreign ownership is permitted in telecommunications. In transportation services, it varies from 40% to 100%. In Thailand, 100% foreign ownership is permitted for electricity production, tap water, and so on. So, I just gave a few examples, Your Honor. If I may also be permitted to, I also understand that it was mentioned earlier that the Honorable Representative has taken the position that public utility definition has remained constant pre-enactment of 1935 Constitution till to date. If I may point to the record, Your Honor, that the pub in Epira, electric power generation was declassified as a public utility. Also in Republic Act 10668, also as regards that aspect of domestic shipping that was declassified as a public utility.
Well, let me just interrupt. That is not my question.
Yes, Your Honor.
Okay? So I can add more.
Yes, Your Honor.
To your answer. Scottish Water was never privatized. It's publicly owned and is the most trusted utility in the UK, delivering cleaner rivers, lower bills, and more investments per head. Ireland, mail, rail, buses, and water are all publicly owned in the Republic of Ireland. Switzerland, the railway in Switzerland is publicly owned, and it has been the best train company in Europe. Denmark has the highest proportion of wind power in the world. Its transmission grid is fully publicly owned, and most wind farms are cooperatively or community owned. Netherlands. In Netherlands, water, electricity, and gas networks are all publicly owned, and it is illegal to privatize any of them. In Slovakia, publicly owned railway provides for free rail transport for children, students, and pensioners. In Germany, the city of Munich in Germany is developing 100% municipal and 100% renewable energy by 2025, owned by the state. Also in Germany, 88% of all trips on local public transport, bus, tram, and local trains are provided for publicly owned operators. In Greece, the Greek government is installing free Wi-Fi in 3,000 public spaces, including public squares, pedestrian zones, playgrounds, municipal buildings, and museums. France, the post office in France is publicly owned. Its services include banking, insurance, driving tests, fresh food delivery, and home visits for older people. Also in France, water is also publicly owned in hundreds of French cities. One of these is Paris, where the public-owned company has cut bills and introduced steel and sparkling water fountains. In India, the Indian government has nationalized several industries, including coal, oil, and natural gas. In Venezuela, the Venezuelan government has nationalized industries such as oil, steel, and cement. This is also likewise in China, as well as in Cuba, as well as North Korea. So, why are we trying to liberalize ownership of public utilities when these are services very close to our people's interests? And we are not only the one having this nationality requirement. In the Philippines, we even give it a 60-40%. 40% for foreigners. But in other countries, which I have said, they are completely owned and operated by the government. Can we have any response or comment from the resource persons?
Mr. Chair,
Majority
may I move that Mr. Orion Perez Dumdum, the chairperson of Correct Movement, be allowed to answer the question.
Yes. Okay. Mr. Dumdum. Yes. Thank you very much, Mr. Chair. To the Honorable Representative, I just wanted to point out that several countries allow telecommunications to be owned by foreigners. So in Australia, for example, the mobile company known as Optus, which is an Australian company, is actually owned 100% by Singtel. I know this because I have lived in Singapore since the year 2000 and only came back last January 14. So that's one example of a case where you have 100% ownership by a foreign company in a telecommunications, basically a public utility in a country. That's Australia. We have, in the case of Vodafone, Vodafone is a British company, also in telecommunications, and it operates as a majority owner of telecommunications in the Democratic Republic of Congo, in Egypt, in Lesotho, in Mozambique, in South Africa, and Tanzania. So, I mean, there are these examples. There's also the case of in Scotland, for example, they have the Singapore company called Comfort Delgro, which is the operator of buses and public transport. They are the ones who handle some buses and cabs in Scotland. And I saw this myself because I visited Scotland several years ago. So there are just a few of these examples that exist in numerous countries in the Nordic region. There's Denmark, which also allows foreigners to own telecommunications companies as well. So I don't think this is a unique situation. You know, this is something that's done by many different countries where they allow competition, they allow foreign ownership or foreign participation, majority participation in their public utilities sector. That's all I have to say. Thank you.
Those examples will not negate the fact that in many more countries, they have nationalized the operation, the service of basic, essential public interests like water, electricity or power, transportation, among others. So I think we should be able to appreciate this situation where, with respect to public utilities, there should be the controlling interests of the state in favor of the interests of the people. I will be winding up. I will be asking for a second round, but may I suggest that the Philippine Statistics Authority be also called next time, because I have some questions with respect to the data on the economy.
Mr. Chair, we have 3 resource persons raising their hands to answer the questions of the Honorable Edsel Lagman. May I move that they be recognized in succession? Attorney Donato of Tanggulang Demokrasya, Ibon Foundation, Mr. Sani Africa, and Undersecretary Sharon Garin. So move, Mr. Chair.
You're all recognized, and please, if there's anybody who feels free to, who would want to give their opinions on the interpolation of the good congressman from Albay, feel free. Yes, you're recognized, attorney.
Thank you, Mr. Chair. Honestly, I cannot comment on the experience of other countries that they nationalized and supposedly they did better. What I can recall is our own experience, PLDT. For those of us who were around already when it was still government owned and controlled, it took 10 years to apply for a landline. Philippine experience po yan on how government operates a public utility. Then it was privatized. You had PLDT, you had Globe, now you have Dito. You can get a mobile phone anytime. Yun lang po. So when it comes to efficiency, so that is the Philippine experience. Thank you po.
Quick reply po kay Rep. Lagbat. I think the representative raised a very important point. A lot of people are obsessed with the numbers about open or not to foreign investment, how much is allowed or not. I think, for instance, in the case of Thailand, despite nominally 49% ownership allowed, actually there's almost a monopoly of state-owned power generation in Thailand. In Indonesia, again, it supposedly allows on statutory 95%, but actually the distribution is virtually a state-owned monopoly. In Vietnam, well, Vietnam is statutory closed in distribution and transmission, and of course, it's a state-owned monopoly. So I think one important point being highlighted here, which I think is worthwhile to research, hindi lang tignan ano yung pwede, kundi ano yung actual. Kasi apart from the foreign investment restrictions, countries have a lot of, governments have a lot of room to restrict the entry of foreign investment out of national security, out of other interests. There are other regulatory measures apart from the actual ownership restriction, pwede pa tumbling for environmental regulations or all sorts of other regulations. Pero our contention is, in the case of the Philippines, if we come from a premise na hindi porke may foreign investment maganda, if you come from a premise that it would be nice to have a publicly owned enterprise, how do we build capacity? Opening up to foreign investment in a context that we're so obsessed with foreign investment will actually prevent that kind of long-term capacity to be built up. Yun lang po.
Yes, to be recognized, Congresswoman, former Congresswoman, now USEC Sharon Guerin.
Mr. Chair, I just wanted to make emphasis on the renewable energy. For 15 years since the passage of the renewable energy law, there was a restriction under IRR that it was nationalized, confined to the 60-40 limitation. But since 2022, this was lifted by order of the Department of Energy. Now that there's no limitation and 100% ownership of foreigners is allowed in the generation of renewable energy, in 2022 this was lifted and we have issued 114 service contracts at that year, amounting to 9.99 trillion pesos on the estimated cost of investments. And on 2023, there are 275 new contracts estimated at 8.527 trillion pesos. So it's just to show that the limitation of the 60-40 at that time, by lifting that, there was the increased competition and increase also on capital available for this projects, Mr. Chair. Thank you.
Thank you very much. Majority Leader, are there any other resource persons who would want to shed light on the queries of Congressman Lagman?
If there are none, can I just make a quick response?
Congressman Lagman, you may proceed.
Yeah,
Well, in the
Mr.
case
Chair.
of... May I be recognized?
Quick response.
In the case of PLDT, for example, after it was privatized, what was the ratio of domestic versus foreign ownership?
Whom was your question directed to?
My question is to the resource person who spoke on behalf of PLDT.
The resource person?
Nawala na.
Majority Leader?
Anyway, let me just say that in Singaporean law, no distinction is made between domestic investment and foreign investment, except for limitation on foreign ownership in telecommunications, financial services, and the national airline. Also, there can be no foreign ownership of public utility services, arms, and ammunitions. In Japan, there are 12 key sectors where the government plans to limit foreign investments. And this would include defense, nuclear power, aerospace, utilities, gas, cybersecurity, and telecommunications. So this is even a reverse trend on opening up the economy to foreign investments, because there are other areas in the economy, like manufacturing, like retail now, or banking, where foreigners can come in without any strict restrictions. I will ask for a second round, Mr. Chairman.
Thank you very much, Congressman Lagban. Majority Leader?
Mr. Speaker, to give way to the session set at 4 o'clock, I move that we, in the meantime, suspend consideration.
Sir Chairman, may I just request, we still have 9 minutes. If I can have my 9 minutes before the 4 o'clock. I have been listed. I'm the next one.
Yes,
Mr. Chairman, but it's possible because
Congressman Rodriguez, we will have to prepare plenary.
Yep.
So the staff will have to come in and clean up the room.
Yes.
I would like to appeal to that, Mr. Chairman, because we would like to have these questions. It's only 9 minutes to be able to ask, because we have here the distinguished persons, Mr. Chairman.
Majority Leader.
So I'd like to ask for your consideration.
Mr. Chairman, I may just, the whole committee is a creation of the plenary. And the plenary is about to start our session at 4 o'clock. So, in this light, to allow the staff, the plenary staff, to prepare the hall for the resumption of session at 4 o'clock, I move that we, in the meantime, suspend consideration of House resolution of both Houses number 7. So
there's a motion to suspend consideration of House Resolution number 7. Any second? Any objections? There being none, motion is approved.
I move that we suspend, in the meantime, the committee hearing to give way to the session to continue after the adjournment of our afternoon session. So moved.
Is any objection? There being none, motion is approved. To our dear resource persons, drinks and snacks will be served at the North Lounge lobby. So we invite you to please fill yourselves up, because we hope that you can stay longer, because there are a lot more questions that our good colleagues of the 19th Congress have prepared for you. So we just have to have a short session before we proceed. And before we go, Congressman Rufus Rodriguez, because of your kind indulgence, we will give you an extended time later when you interpolate. Another 5 minutes.